Hey folks, elder law care attorney Patrick Kelleher coming to you from our Elder Law Care Center in Hanover, Massachusetts. Thank you for joining us today. Folks, I am going to teach you today on what the anti-lapse statute is, or maybe in the vernacular, maybe more understandably, what if my beneficiary dies? Or what if my beneficiary pre-deceases me? That's a common question I often hear from folks. So I want to address that, folks, for you here today. Anti-lapse statute is actually a law, and it's recognized by the Uniform Probate Code. And here in the Commonwealth of Massachusetts, Massachusetts adopted the Uniform Probate Code between the year 2009 and 2012. And with that, Massachusetts adopted the anti-lapse statute from the Uniform Probate Code. What does it mean, folks? So I'll give you a basic example. Bill and Mary, parents, create their will or their trust, and they say their 3 darling children get everything when they're gone. Their children are Mo, Larry, and Curly. Let's say, for example, Mo pre-deceases their parents, Bill and Mary. What happens to Mo's share? Well, let's discuss that. Well, the anti-lapse statute would say that Mo's share does not lapse, meaning that Mo's share would go to Mo's descendants, usually Mo's child or Bill and Mary's grandchild. So let's explore first, folks, from my experience, a good way to explain the anti-lapse statute is this. What does the word lapse mean? The word lapse means to fail, or to not happen. It lapsed, like an insurance policy lapsing, you no longer have coverage or protection. Or the word anti, what does the word anti mean? It means to stop and to avoid the policy from lapsing, or to stop the protections or the benefits from happening, okay? So the word anti means, folks, is to stop or be against the lapsing of the gift, okay? So anti-lapse statute would say, hey, Mo's gift does not lapse. It does not fail, because if it fails, then the question is, who does Mo's 1/3 go to? Does it go to his children, the grandchildren of Bill and Mary, or does it go to Mo's brothers, Larry and Curly? The anti-lapse statute will say that the gift does not fail and that the gift goes down to Mo's children or Bill and Mary's grandchildren. And so that's the general rule of the anti-lapse statute. There's specific language in the Uniform Probate Code that talks about it has to be a blood relative of the testators who made the will. So it would have to be maybe a grandchild, a lineal descendant is the legal terminology they use. So usually a grandchild. Who does the anti-lapse statute exclude? Well, it excludes all non-blood relatives, which could be stepchildren, could be in-laws, could be husbands and wives. So Bill and Mary might be thinking, well, if Mo, Larry, or Curly predecease me, we love our in-laws, they'll get their share. Not so, according to the anti-lapse statute. So folks, long and short of it, make sure you work with your estate elder law attorney to put in place what I call contingencies. Contingencies or contingent beneficiaries. Always plan for who your primary beneficiaries are in your will and your trust, Mo, Larry, and Curly, but also plan for contingent or backup beneficiaries. What if Mo, Larry, and Curly predecease Bill and Mary, their parents? Who gets Mo, Larry, and Curly's share? Usually, from my experience, most folks will say, hey, Patrick, I want their share to go to their children, our grandchildren. We want to keep everything in the family bloodline. Really, really important to spell that out in your will and in your trust, because not all states have adopted the Uniform Probate Code. For my recommendation, generally speaking, 2 ways to avoid a gift from lapsing is, number 1, have a backup contingency or a backup beneficiary in your will, in your trust. Also, remember, folks, to do your annual reviews. That's part of our process here. We do annual reviews with our clients to slay the four-headed beast of estate planning and elder law. Do those annual reviews for the 3 L's: changes in law, changes in life, changes in learning, and update your attorney if there's anything going on. For example, if you're a beneficiary, your child, for example, maybe has a change in health and they're not doing well. You want to make sure that your will or your trust is updated accordingly, so if they do pre-decease you, you're clear on where their share will go after you go to your cloud. Hey folks, elder law care attorney Patrick Kelleher. Thanks for joining us today. If you found this video helpful, please post a comment or a question below. Please like, subscribe, and share our channel with those you think could benefit from this information. Folks, if you'd like to learn more, go to our website, elderlawcare.com. Click on the tab Elder Law Academy and check out my book that's on Amazon, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law. Because, folks, we will teach you how to slay the beast. We will teach you how to have a strong shield and sword to slay the metaphorical beast of estate planning and elder law, which is probate court, estate death tax, financial creditors and predators, and that $15,000 per month nursing home in some states like here in the Commonwealth. Folks, if you'd like to learn more, click on elderlawcare.com, post a comment below, and we will see you next time at elderlawcare.com.